Number 2. Hugo Grotius. In De Jure Belli ac Pagis, Grotius begins his account of the origins of private ownership by saying, "Soon after the creation of the world, and a second time after the flood, God conferred upon the human race a general right over things of a lower nature. All things were then the common and undivided possessions of all men, as if all possessed a common inheritance. As a consequence of this general right, which Grotius says took the place of private ownership, each person could take whatever he wanted for his own needs, and what had been taken another could not take from him except by an unjust act. In Mare Liberum, Grotius had said that this right to use the earth's resources was a limited kind of sovereignty, which amounted to the privilege of lawfully using common property. He noted that the civil law concept of an use right is a particular right held against another person. However, the right to use the fruits of the common without owning the substance of things could, by analogy, be understood as a kind of use right. Under Roman law, however, the right to use the fruits of another person's property carried the obligation to preserve the substance. Strictly, therefore, there could not be a use right, as Justinian says, in things such as are actually consumed by use. Grotius is alluding to this feature of Roman law when he remarks that since there are some things the use of which consists in their being used up, it became apparent that a certain kind of ownership is inseparable from use. For own implies that a thing belongs to some one person in such a way that it cannot belong to any other person. In De Jure Belli, Grotius changed this characterization of the primitive use right. The emphasis was no longer on the distinction between using and using up, but on the difference between uses that entailed actual physical possession, and uses that required extended control over objects such as flocks or land. The exercise of the primitive right to use the common must begin with the actual seizure of the thing, that is, with the connection of body with body, and it continues only so long as this connection is maintained. Grotius illustrates the way the primitive right worked by citing the famous example of the public theater. Although the theater is a public place, yet it is correct to say that a seat which a man has taken belongs to him. The primitive right is thus confined to use and to uninterrupted possession. It was therefore adequate only so long as men were content to live a simple life, that is, as long as they were content to feed on the spontaneous products of the earth and to dwell in caves, to have the body either naked or clothed with the bark of trees or the skins of wild animals. People left the primitive stage of simplicity because they desired a more refined way of life, and this led to the invention of agriculture and grazing and some interchange of commodities. Specialization created rivalry and then, as the number of men and flocks increased, to scarcity. As a result, the primitive right was inadequate to preserve harmony and private ownership was introduced. Private ownership differs from the primitive rights in the following respect. Both must begin with an actual seizure, but ownership that arises from private property is not lost when possession is lost, rather ownership gives us the right to recover possession. In most cases, the right to recover possession exists as long as the intention to possess is maintained, and as long as the intention is clearly indicated in ways that others recognize. Thus, shepherds must mark their flocks in some way to indicate that they regard them as their own, and that they intend to recover possession. And in case of land, erecting buildings or fences to determine boundaries is required to indicate that occupation is permanent. In Mare Liberum, Grotius says that this transition did not come violently, but gradually, nature herself pointing out the way. And in his defense of Chapter 5 in Mare Liberum against William Wellwood's criticisms, he says that property in things other than the sea became private property through nature. To establish these claims, Grotius starts from his observation that the idea of ownership is inseparable from the primitive rights of use, and then argues that this idea of ownership was extended by a logical process of reasoning from things by which use become part of the very substance of the user and can never be used again, to things such as clothes and movables and some living things which, although not used up, become less fit for future use. Grotius says that after the first extension had come about, not even immovables, such, for instance, as fields, could remain unappropriated. A law was subsequently established to codify this established practice. When property or ownership was invented, the law of property was established to imitate nature. Now, Grotius' attempt to argue that property in land is simply a logical extension of the natural use right is undoubtedly the weakest part of his theory in Me Liberum. The implications of this change are momentous because the private ownership of the substance of the common, as opposed to the fruits, fundamentally changes the terms on which human beings can provide for their own subsistence. Grotius realized the implications of this early in the development of his ideas, and in his reply to William Wellwad, he says that in cases of necessity, when people lacking the natural right to use natural resources face starvation, the things that had become private property revert to common property. However, the obvious problem is how this argument can be maintained alongside the, as yet unqualified, natural right to acquire property. A further problem with Grotius' argument in Me Liberum is that he clearly acknowledges that occupation is inherently conventional in the sense that it depends on social recognition of the actions or signs that constitute a successful and valid occupation. Grotius resolves both of these problems in De Jure Belli when he says that abandonment of common ownership and the transition to private ownership were accompanied by agreement. It could not come about by a mere act of will, for one could not know what things another wished to have in order to abstain from them. And besides, several might desire the same thing, but rather by a kind of agreement, either expressed or by a division, or implied as by occupation. Grotius then argues that the agreement that introduced private ownership, like all agreements, must be interpreted in the light of what we know or can infer about the intentions of the parties involved. And he says that we are forced to believe that it was their intention to depart as little as possible from natural equity. It follows that in direst need, the primitive right of user revives as if community ownership had remained. Grotius could now consistently claim that for people who face starvation, the original common right of use revived. This gave them a right to take what they needed from the surpluses of property holders. It is important to stress against interpreters who have tried to downplay the importance of the agreement in Grotius' mature theory in order to ascribe to him a natural rights theory of property, that the right of necessity depends on the existence of such an agreement. Without it, those who have not acquired their own property through either division or occupation face starvation. Number 3, Smith. A. Property and possession in the first age of society. Grotius had used a wide range of sources to construct his theory. To establish his initial premise that natural resources were originally subject to common ownership, he referred to poets, philosophers, and historians in De Jure Belli to the Bible, and in De Jure Belli to the Bible. He then relied primarily on Roman private law, and in Me Liberum also on medieval theologians and lawyers, to achieve two things: to provide an interpretation of common ownership in terms of the use right that it implied for individuals, and to interpret the Roman law of occupation as an explanation of the origins of private property as an institution. For Smith, as for other Scottish writers from after Hutcheson, there were no interior rights that could explain a primitive right of use, and Smith builds his theory exclusively on the basis of Roman legal remedies. In particular, Smith says that the first uses of the world in hunting and gathering societies were explained by the Roman law principle of occupation. However, occupation under the Roman law required two things: physical attachment, corpus, and the willingness or intentions to have things as one's own, animus. And this latter element was dependent upon social recognition. This is why Grotius eventually came to the view that when the principle of occupation was introduced, it had to be accompanied by an agreement. One solution was to bring the agreement forward in time as Pufendorf had done. However, an alternative presented itself to Smith in the form of the Roman law disputes among the application of the concept of occupation in the case of capture of wild animals. The central question here seemed to be how far the intention to have and use the thing could be inferred without actual physical attachment. While this was a controversial question, the standard view was, as Grotius reports in De Jure Belli, that wild animals cease to be our property as soon as they regain their natural liberty. Similarly, in Mere Liberum, he had said that occupation or possession in the case of things, such as wild animals, that resist seizure, must be uninterrupted or perpetually maintained, and that these cases differ from most other things where it is possible to indicate one's intention to maintain ownership after the initial seizure. This is elaborated in De Jure Belli when Grotius says that ownership is not lost simply because the animal has escaped, any more than we would lose ownership of a runaway slave. Rather, it is because of the natural inference that we have abandoned ownership on account of the difficulty of pursuit, especially because the wild animals which belong to us cannot be distinguished from others. He says that a thing once possessed is lost if the hope of its recovery is abandoned, and this is judged to be the case when recovery seems impossible, that is, in cases in which there is no reason why anyone should be expected to retain the thought of ownership when no indication of such an intent exists. Now, according to Grotius' interpretation of the Roman law, hunting was an exception to the general rule of governing occupation, but it showed that the corporal element of physical attachment alone, that is, the bare possession of the object, was, in this case at least, enough to indicate that the possessor had both the intention and the reasonable expectation of having the thing as his own for as long as he retained effective control. What I think Smith came to realize was that the Roman concept of occupation of wild animals could be used as a model for the most primitive forms of property. A legal distinction that had distinguished hunting from other acts of occupation could be used as a historical distinction for identifying a separate age of hunting. Initially, therefore, all things were regarded in the same way as wild animals continued to be, and ownership did not extend beyond possession. Smith thus attempted to construct a theory of property in the age of hunters from the resources of the Roman law, and it is in this context that his discussion of occupation in the case of wild animals and the lectures on jurisprudence assumes a significance beyond a routine treatment of a standard topic of law. He begins his discussion of occupation, however, with the general assertion that property in a subject is not conceived to commence till we have actually got possession of it. As we have seen, this principle had also been affirmed by Grotius, who had originally used it in Mere Liberum as part of his case against the claims of the Portuguese to the lands of the East Indies and to the exclusive use of the sea for navigation. But it was by no means the standard view, except in the case of wild animals. The significance of the principle as a general principle of property acquisition is that people cannot be said to have rights to things growing on the common, or to animals in their wild state before they are captured, or to the land itself prior to physical appropriation. Property titles cannot be acquired by the performance of labor, or by the mere intention to take or to have the thing, or indeed to discover, by discovery, a point that Grotius made in his case against the Portuguese. This is a point of considerable importance in Smith's adherence to Grotian conception of justice, in which property rights were rights in what we have or possess, rather than rights to one's due. Smith, however, having stated the principle that occupation begins with actual possession, immediately proceeds to a discussion of the Roman laws of hunting. He upholds the majority opinion, as Grotius had done, that property acquired by occupation of wild animals must always begin with actual possession. He considers some different legal opinions and some exceptions, but concludes that property was conceived to commence when the subject comes into power of the captor. Hutcheson, having argued that the right of property is a right that we have in the fruits of our labor, was committed to an alternative view, as Locke had been, that the property of the hunter begins when he has wounded or tired the animal. It is important to stress here that Smith was returning to the older and more dominant tradition of the digest and of the modern natural law tradition for which the digest was such an important source. Smith then asks, how long and in what circumstances property acquired by occupation continues, and at what time is it supposed to be at an end? Now, it is really only at this point that the reader of the lecture notes, and perhaps also Smith's students, realize that Smith is giving historical answers to the questions with which he begins his discussion of property rights. Up until this point, Smith's discussion of occupation has all the appearances of a standard treatment of a standard topic of Roman jurisprudence, and he covers the same ground and comes to much the same conclusions as Grotius had done, but it becomes apparent that his discussion is a historical one when he says, at first property was conceived to end as well as begin with possession. Smith then proceeds to elaborate on the extent of property in the first age of hunters. In general, he says that a thing was not considered to be ours once we had lost the immediate possession of it. For example, if having pulled an apple from a tree I should happen to let it fall, and another should snatch it up, this would be a very heinous affront, but not a breach of property. Similarly, a wild animal that escapes ceases to be the property of the one who captured it. Once the animal escapes, I can have no longer any claim to it any more than to any other wild animal, as there is no greater probability that I should snatch it. Smith thus reaches the same conclusion as Grotius, that in the case of hunting wild animals, property ends as well as begins with possession. But Smith has transformed a standard legal discussion of a particular activity into a discussion of property in a particular historical age, and he concludes with the remark, in this age of society, therefore, property would extend no farther than possession.